Will the courtroom clerk please open court?
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice, presiding.
Huffaday Council and the students, teachers, and professors from George Washington High School and the University of Guam. I also greet the members of the general public and the media who may be viewing this hearing on the court's YouTube channel. I am Chief Justice Philip Carbolito, and along with my colleagues, Justice Robert J. Torres and Justice Catherine A. Merriman, I wish to welcome you to the virtual courtroom of the Supreme Court of Guam. May 1st of every year marks Law Day, a national day set aside to celebrate the rule of law and to reflect on how law and the legal process contribute to the freedoms we all share. This year's National Law Day theme is Advancing the Rule of Law Now. This theme reminds us that the rule of law is the bedrock of American rights and liberties in times of calm and unrest alike, and that we, the people, share the responsibility to promote the rule of law, defend liberty, and pursue justice. Over the years, Guam's Law Day celebration has grown from Law Week to Law Month. As part of our annual celebration, the Supreme Court partners with one of the island's high schools or colleges to hold an outreach appellate argument. During this event, students watch live arguments in a real pending case, which gives them the unique opportunity to witness firsthand the appellate process in action and to participate in a question and answer session with the justices and attorneys in the case. Under normal circumstances, an outreach argument entails bringing the courtroom to your campus with the justices, attorneys, court marshals, and courtroom recording all in tow. But just as your way of attending classes has changed, so has the way of our court hearings. Since the start of the public health emergency, the Supreme Court of Guam has become a virtual court, hearing all of our cases over Zoom with a live stream on YouTube, as we are doing this morning. Although a virtual courtroom has its share of challenges, it also has certain advantages, such as an event like today, where we can provide access to a Supreme Court hearing without the limitations of space in a physical courtroom or even the constraints of the public's time, since a recording of our virtual hearing can be viewed on our YouTube channel any time of day from any part of the world. Before we start today's hearing, I just want to give you a brief overview of the function of our court. I am sure when students and adults alike think of a court hearing, they imagine the trials they see on shows like Law and Order, where witnesses take the stand and jurors decide the fate of someone charged with a crime. I just want to warn you that this is not what you will be seeing today. Trials are held in the Superior Court. When a decision is rendered in the Superior Court, the parties in the case have a right to appeal the decision to us at the Supreme Court. An appellate hearing does not involve taking evidence from witnesses or viewing exhibits, and there are no jurors involved. Instead, the issues in the case are argued by the attorneys representing both sides, while the justices ask the attorneys questions about the law and the record pertaining to those issues. Definitely not as exciting as a Law and Order episode, but to the parties who come before us, we represent, for the most part, their last resort at winning their case. Today's case, however, did not come before us through the route I just described. Rather, this case involves the Supreme Court's original jurisdiction when a case can come directly to the Supreme Court without first going to the Superior Court. Guam law allows the governor to file a request for declaratory judgment, where the governor asks the Supreme Court to interpret federal or local laws and any questions affecting the powers and duties of the governor and the operation of the executive branch. Today's arguments will focus on the questions raised by the governor concerning her quarantine powers. I'd like to thank counsels for today's case for graciously agreeing to not only argue in front of a much bigger audience than they're probably used to, but also to answer some of the students' questions after the hearing. The questions will not pertain to any matters in the case, and as Justice Torres will explain further, he will, in addition, brief us on some housekeeping rules, and that we can get so we can get started with today's hearing. And with that, Justice Torres, I will turn it over to you.
Thank you, Chief Justice. Half a day, everyone. Just a few housekeeping and logistic rules for the students who are attending this virtual oral argument. All of the attendees are going to be muted except for the panelists in the virtual courtroom currently. We have disabled the chat function, so you won't be able to chat directly with the panelists, although the panelists can send a message to all the attendees and to other panelists. We are going to field the questions that you have through the question and answer box. If you look at the screen, you'll see a question and answer box in the middle of the screen. And we encourage you to submit your questions throughout the oral argument and directed to either the attorneys or the justices. And as the Chief Justice indicated, we will not discuss any of the merits of the case, but you can ask about the process and the procedure and just general questions about the law or what it's like to be an attorney or a jurist. We will respond to the questions and any comments at the conclusion of the oral argument. And we're also using a upvote feature. So you'll notice in the Q&A when someone asks a question, if you click the thumbs up icon, you'll upvote that question and we'll try to answer that question first. The questions with the most upvotes will be answered first in the event we don't have time to answer all of your questions. We will also give students an opportunity, if they would like, to actually join us here in the virtual courtroom. So if you ask your question and would like to be admitted into the virtual courtroom, please indicate that you would like to be admitted or put yes, and we will actually admit you so that you can ask your question live to the justices or to the attorneys in the virtual courtroom and join us. We'll beam you up just like in Star Trek days. So yeah, with that, thank you very much.
Thank you, Justice Torres. And so counsels, we are ready to begin. And will the clerk please call the case?
This is Supreme Court case number CRQ20-002. In re request of Lourdes A. Leon Guerrero, Imaga Hagan Guahan, relative to the power of the executive branch to establish, maintain, and operate quarantine facilities in Guam, and to promulgate quarantine and sanitation regulations for the people of Guam against the importation and spread of disease. Appearing for the petitioner is attorney Sophia S. Diaz and attorney Leslie A. Travis. Appearing for the interested parties, incoming travelers subject to quarantine, is attorney Brian Eggleston. Appearing for the interested party, the 36th Guam Legislature, is attorney Anna Wanpat Borja. Appearing for the interested party, Department of Public Health and Social Services, is attorney Joseph Paris. Appearing as Amicus Curiae for the Office of the Attorney General is attorney James L. Canto and attorney Jordan Palhoun. The panel consists of Chief Justice F. Philip Carbolito, Justice Robert J. Torres, and Justice Catherine A. Merriman. Attorney Travis reserves 10 minutes.
Thank you, Madam Clerk. Attorney Leslie Travis, you are now recognized. Please proceed.
Thank you. Good morning, Mr. Chief Justice, Justice Torres, and Justice Merriman. May it please the court. Your Honors, this case now involves 5 parties. 7 briefs have been filed. The issues in this case have grown. Now this case will impact the future of our island in the face of unprecedented public health emergencies. We are quite literally advancing the rule of law now. But at its core, the primary issues in this case remain the same. Specifically, what standards should the trial court use in reviewing challenges to quarantine orders during the COVID-19 pandemic? The quarantine statutes codified at 10 GCA 19604 and 19605, as petitioner submits, are inorganic. The constitutional standard should be applied and not the standards that are provided in the statute, purportedly provided in the statute. If the statute does survive an Organic Act review, the trial court is still constrained by the statute to review simply whether a quarantine order is reasonably necessary to prevent transmission of disease. I would like to start with the Organic Act argument first.
Before you begin with the merits of your argument, Attorney Travis, I do want to ask a question in reference to jurisdiction that Attorney Eggleston raised it in his initial opening brief, and he also raised it in his supplemental brief. He raises that under our 4104 original jurisdiction, we could entertain original question jurisdiction when in questions interpreting the law and under two areas, and questions affecting the powers and duties of the governor. In this particular case, initially we had granted jurisdiction under questions interpreting the law, and that's, the Title 10 is specifically 19604 and 19605, 19601. And but in looking at the arguments and the briefs, this case has kind of evolved, and I'm just questioning now in my mind whether 4104 original jurisdiction grant is a proper vehicle to hear these issues, because we originally granted this case where there was the governor had sought an interpretation as to the meaning of these statutory sections. And now there is a question as to the validity of the statutes, an attack on its constitutionality. Not that we don't have the power to do that, but just whether or not this is the proper vehicle in which to hear these arguments. So I guess my question is, Mr. Eggleston continues to challenge and question the court's granting, and that we may have improvidently granted original case jurisdiction or 4104, since we're no longer seemingly focusing on the meaning of the statute, but it goes to the very essence as to the validity of the statute, and that may exceed our original grant of jurisdiction regarding questions interpreting the law. Can you comment on that?
Yes, Your Honor. In the court's December 31st, 2020 order, the court granted a review over two specific issues. I'm going to focus on the second issue because that was the justification that the court used in enlarging the issues at a later order on the March 9th order. But the second issue that the court agreed to review was the question of, may a court modify a quarantine order issued by DPHSS? If yes, under what circumstances may a court modify a quarantine order issued by DPHSS? As the court is aware, the Public Defender Service Corporation, which represents interested travelers who are challenging quarantine, they have actually submitted in this case that the delegation of authority from the legislature to the Superior Court of Guam in reviewing the quarantine orders that are issued to incoming travelers actually gives the court an active role, in effect allowing the court to modify existing policies that are issued by the governor's office and public health in coordination with public health. To that end, it's the governor's position that, to the extent that that the Emergency Health Powers Act purports to delegate that authority to the Superior Court of Guam, they can't. The legislature can't delegate any more authority than they actually possess. And in this case, the Organic Act does not give the legislature power over quarantine. That power vests in the governor pursuant to the plain terms of the Organic Act. And therefore, the court may not modify a court order, even if the legislature purports to delegate that authority to the court. And this is consistent with this court's order on March 9th, in which the court held.
So are you accepting then that the 6104 and 6105 is organic, constitutional, and it's only that in the interpretation of those statutes that the court is not able to do this review that you are contesting, and not necessarily that the statutes are inorganic?
I don't believe, I think that this is where our office disagrees with the office of the Attorney General. With regard to 19604, if that can be interpreted as a statement of considerations that the legislature would like the governor to take into account when she promulgates her quarantine regulations, we have no quarrel with that. The legislature can make whatever recommendations they would like to make to the governor. However, under 19605, there are a few things that happen. First of all, you're only allowed to temporarily quarantine individuals for a 10-day period. Obviously, that doesn't work with the timeline, the incubation timeline for COVID-19. And this was intended to be a general statute. It was in fact a cut and paste of the Model Public Health Act. However, this has been interpreted, of course, to limit the governor's authority to quarantine an individual for 14 days. The very act of saying that you have to release these people in 10 days unless you come forward and tell us why they have to stay, that goes against the governor's regulatory power over quarantine under the Organic Act. Second, it allows the court, it does allow the court, I will concede this, per the express language of 19605, it states that the court is supposed to review whether or not it's reasonably necessary to prevent or limit the spread of the risk of transmission to continue the quarantine of individual travelers. And that also allows the court to, even though it's certainly more limited than what the Superior Court has been interpreting it to mean, expressly on the face of 19605, it allows the court
But Ms. Travis, it now sounds to me that the objection of the governor is the application of the statute to the facts of the case. And as argued by Mr. Eggleston, that may be better served by the ordinary appeal process than when we have a factual record and we determine whether or not the statute is being properly implemented.
Chief Justice, actually the position of the governor is that it is inorganic. The very act of limiting her ability to continue the quarantine of these individuals, the very act of delegating authority to the Superior Court to review her policy in that kind of detail violates the Organic Act. The statute is inorganic because it purports to confer authority on the Superior Court of Guam that the legislature doesn't even have itself. It's inorganic because it allows the court to review the policy, and not based on constitutionality.
So the court invoking its 4104 jurisdiction is not then taking up the challenge based on interpreting the law, but now it's on the actual powers and duties of the governor under the Organic Act. That is what you are emphasizing this morning.
It is both, Your Honor, because the court does have to interpret the statute as well in order to get to resolve part of the argument. But I would agree, the statute is inorganic. If the court does find that it's inorganic, the court has to interpret the statute.
Well, the court finds it's inorganic, it strikes it down, and we don't have to interpret anything.
Agreed, Your Honor.
Ms. Travis, let me ask a more basic question. Has the governor exercised her Organic Act power to promulgate quarantine regulations?
We would submit, Your Honor, that she does that every time she issues a quarantine regulation or a quarantine policy in coordination with the Department of Public Health and Social Services through the executive order and the public health guidances that correspond to the executive order.
So there are a number of executive orders where the governor has indicated that, and they are, that she is restricting entry into Guam and persons are subject to quarantine. And she actually cites 19604 and 605, and then says that the quarantine is going to be administered in accordance with applicable public health guidance. And over time, public health has issued various guidance on quarantine procedures. How does that relate to the quarantine regulations that are contained in the GAR, the 26 GAR, that are the regulations that correspond to the Emergency Health Powers Act? Have they relied on those regulations or not?
The court certainly has relied on the regulations, and Your Honor, to the extent that the governor has even referenced the Emergency Health Powers Act, it was with the intent to work with the legislature and take their considerations into account. However, it does not in any way waive her authority, her ultimate authority under the Organic Act to regulate quarantine herself without approval from the legislature.
So in order to determine what the quarantine regulations are that the governor has promulgated, we must look to not only the executive order, but to the guidance from public health, is what you're saying.
The executive orders always reference applicable DPHSS guidance memorandum. And actually, if you look at the executive order, of course, it's intended to be broad strokes. The details are contained in the public health guidance memorandum. If I may proceed, Your Honors. Section 1421 GA of the Organic Act of Guam vests ultimate responsibility and concomitant authority over the governance and regulation of quarantine and the governor of Guam. Now, it's been suggested by some of the other parties, some of the interested parties, that this proposition is somewhat audacious, that it results in some kind of unicorn unification of powers that was never intended in the Organic Act, that's inconsistent with the American way of life and American values. But I think that position fundamentally misunderstands the nature of Guam's relationship to the United States. We're not a state. And it's perplexing to me, frankly, why this legislature and this attorney general would somehow try to shield or insist or obscure the fact that we're an unincorporated territory. Now, I understand that it may be uncomfortable in 2021 to hold a mirror to our faces and acknowledge that we don't have state sovereignty or anything equivalent thereof. As this court itself held in Camacho versus Estate of Gumatao, 2010 Guam 1, the court cited to United States to SCOTUS, United States Supreme Court decision in Binns versus United States. This court acknowledged that Congress has plenary power to fashion the territories however it chooses, and in doing so is not limited to the quasi-state forms with 3 respective coordinate branches. The form of government it shall establish is not prescribed and may not necessarily be the same in all the territories. This is
Ms.
plenary
Travis,
power.
in the language that Congress provided in the Organic Act, giving the governor the ability to establish and promulgate quarantine regulations, it did provide that it was subject to the laws of Guam, correct?
Yes, Your Honor.
So
The state
why
law.
doesn't that give the legislature opportunity to weigh in on and have overlapping jurisdiction on the quarantine regulations?
As the Ninth Circuit held in Berdalio versus Baldwin, specifically with regard to the governor's governance powers over the hospital under 1421 GA, the same section that's at issue here, the court held that subject to the laws of Guam doesn't mean usurpation of the governor's authority, the governor's ultimate authority over hospitals, to govern hospitals. What it means is that the legislature, within its own scope of authority, can legislate related acts. For example, because it has the power of appropriations, it can determine how many hospitals there are, where to build the hospitals, that kind of thing. And actually, if the court looks at Title
Well, give
10,
me some examples in the quarantine realm where you believe it's appropriate for the legislature to act consistent with 1421 GA?
Well, there are two quarantine powers that are contained in 1421 GA. The first is to establish, maintain, and operate quarantine stations in Guam. The second is to promulgate regulations for the protection of Guam from the importation and spread of disease. So with regard to the first power, to establish, maintain, and operate quarantine stations, it's the same power that they have over hospitals, almost, I mean, identical. It even appears in the same clause. So if we were relying on appropriations from the general fund to establish quarantine, they could certainly cut our legs off, Your Honors. They could control how many quarantine stations there are, how much money to appropriate to quarantine stations, essentially the budget for our menu planning, if you will, for quarantine. So that's with regard to the first clause, to establish, maintain, and operate quarantine stations. With regard to the second clause of promulgation of regulations for the protection of Guam from disease, they certainly can't usurp the governor's authority by themselves overruling the governor's regulations. However, we think that there are some related laws that they could pass. For example, and I've put a lot of thought into this myself because there isn't any case law on this topic. But I believe that a good law might be to appoint the public defender to represent individuals who challenge quarantine. That's related, but it doesn't generate the policy itself, which is the governor's authority under the Organic Act.
Yeah, but in reference to the specific challenge of 19604 and 19605, so your argument is those sections completely supplant the governor's discretionary authority that seemingly is founded in the Organic Act. You argue that that's a plenary authority not subject to any type of influence by the legislature. And you seemingly draw the parallel with the Baldwin case. But in that case, as I understand it, the governor was rendered as only a figurehead, only had ministerial responsibilities resulting after the change in the statute, which in all practicality took away the governor's powers to appoint the members of the Board of Education. I'm sorry, in terms of the hospital board. In this particular case, the governor is still under 19604 and 605, the person in charge in establishing, maintaining, and operating these quarantine sites and in reference to how it operates. And it's not a complete dilution and taking away all authority of the governor. And so if we're going to give some significance to the language in the Organic Act 1421 GA of subject to the laws of Guam, there must be this balancing in reference to whether or not there's a complete takeover. And that's it may be a stretch in my mind that's what's accomplished in 19604 and 605.
Your Honor, if I may, with regard to 19604 specifically, to the extent that that language is interpreted to mandate to the governor what her policy should contain, it's absolutely a usurpation. In relation to the Bordallo versus Baldwin case, it would be the equivalent of them saying instead of 13 organizations on Guam get to choose the board of trustees from whom you must appoint the ultimate board for the hospital, it'd be the equivalent of saying, well, only 12 and you get to choose one.
Yeah, but counsel, let's step back a bit here in reference to what is it being requested for the court to adopt. When you look at the, first of all, just in response to your earlier about the uniqueness of the Organic Act and the powers that is granted to the governor, we still operate under a democratic form of government with 3 separate but co-equal branches. And separation of powers is still time honored here in our jurisdiction. So we still have that context in which, and there has been a lot of thought and energy put into this model act, in which we have adopted. And there's been a lot of vetting, balancing of interests, and taking into account the competing interests of health and safety and the civil liberties of individuals. So is it the desire of the governor just to completely toss that out and say, just leave it up to me in reference to how I wish to operate, protecting the health and safety of the individuals?
Your Honor, we're only challenging the quarantine provisions, 19604 and 19605. We actually really appreciate the framework that's provided by the Emergency Health Powers Act. It's been very useful. We utilize it in substance.
But that's the essence of Title 10. 19604 and 605 goes to the very heart of how quarantine is established and maintained and is operated. And so you gut that out, and you don't have a structure in which to have the balancing of these respective interests.
Your Honor, even if 19604 and 19605 are found inorganic and void, the governor's policies are still subject to the Constitution in the same way that it is in other jurisdictions. Your Honors, the state of Hawaii actually has some similar language to the Guam statute with regard to least restrictive means available. However, that provision has been suspended during the COVID pandemic, but they're still subject to challenge, the policies that are enacted by the governor, and that's because you're still subject to the Constitution. There's this narrative out there that's been pushed by the legislature in their brief that the governor is asking for unfettered, quarantine power, and that's not true. We're always subject to the Constitution. The Emergency Health Powers Act is subject to the Constitution.
Well, I don't think anyone in this virtual courtroom is going to argue that, the governor cannot discriminate based on race, sexual orientation, and just in terms of those fundamental rights. But in terms of protection of civil liberties, when it's a little more amorphous and not defined, that we may be better served as a community where we have a structured a statutory scheme in which the challenge is to how is that implemented in furtherance of the principles that are sought to be protected there. And it's more the implementation. And it sounds like if we were to toss this out, we're still in the midst of a pandemic, then we need to go and figure out, what are the defined terms now that we are all to be guided as an island in reference to what of our respective rights in reference to quarantine and isolation.
We would be subject to the same limitations that exist in other jurisdictions where there's, the review under Jacobson, Your Honor, would still apply. The priority in Jacobson and in the Emergency Health Powers Act are the same, which is you have to prioritize the public health over individual rights. Are they considerations? Sure. Even under Jacobson, they are. The second part of Jacobson is whether or not there's a plain, palpable violation of the Constitution. The Constitution doesn't get thrown out the window because the 19604 and 19605 are inorganic.
Let me ask this: if we determine that 605 is inorganic, how do you propose you deal with the breaches or remedies for breaches of the conditions of quarantine? 605 provides a process by which the courts can review where the conditions that were laid forth in 604 have not been complied with. For example, if you fail to provide communication to people in quarantine, or don't provide adequate food, or don't provide, respect to the extent possible religious freedoms. How do you propose that those issues be confronted if the provision contained in 605C2 for courts to look to have remedies for that aren't addressed or don't exist?
Individuals can still sue in the Superior Court of Guam because it's a court of general jurisdiction. That doesn't need to be conferred in a statute. But also it's, again, their constitutional rights. If I'm in quarantine and they're not feeding me, I can sue. The statute doesn't give me that right. The Constitution gives me that right.
So what would be the standard of review and the part of the, assuming 19605 goes out, the standard of review in reference to a decision of public health issuing an order of quarantine? How does the trial court determine what principles does it apply to determine whether or not quarantine was appropriate, whether or not there should be a continuing quarantine, whether or not the person may now be released? So what are those standards now for the trial court to be guided by?
It's the same as it is in the majority of jurisdictions in the country. It's Jacobson. It's a Jacobson review.
So it's just a general police power that let's just leave it up to the executive branch in determining how to protect our citizens without more concrete principles or elements or guidance and that will help the trial court.
Your Honor, I apologize, Your Honor.
I was just going to say, don't you think that that would be a real struggle in reference if there's no, if there are no defined standards for the court to apply?
Your Honor, I have full faith in our Superior Court's ability to navigate this in the same way that nearly every other jurisdiction in the country is navigating it.
Well, and last count was there over 34 jurisdictions that have adopted the Model Act.
That have adopted it in part, Your Honor. I'm actually not aware of jurisdictions that use the same standards that we use with regard to this balancing act that the Superior Court has implemented in her review of these standards of these orders.
But 19604 and 19605 is directly verbatim out of the Model Act, which has been, I didn't go and do a survey as to whether all these jurisdictions that adopted specifically also included 19604 and 19605. So I couldn't say at this point.
They've been adopted in part, Your Honor, but with regard to that particular statute, the only jurisdiction that I was able to find that contained the least restrictive means available language, which is primarily what the Superior Court relies on in its decisions. The only jurisdiction I was able to find was Hawaii, and as I mentioned, it's suspended during the COVID-19 pandemic.
I'd like to interrupt to point out that Ms. Travis's time is almost gone. She may want to reserve.
Ms. Travis,
yes, I would like to reserve the remaining time that I have. I would, however, draw the court's attention. I do think that it's an important point to mention simply that that with regard to 1421 GA and 1421 GB, that 1421 GB was amended to remove the power over public schools from the governor and vested in the legislature. So if we're talking about the interpretation of the Organic Act and we're not reinventing the Organic Act, that's what it means. They have to go back to Congress in order to remove this power from the governor, because the ultimate authority is hers according to the plain language, to the case law, to the legislative history for the amendment, to the 1986 legislature, to Ben Blas, to Congressman Udall out of Arizona. I think it's going to be a real struggle to try to explain that away. With that, Your Honor, I reserve my remaining 35 seconds.
and I'll allow you at full 10 minutes on your rebuttal. In addition.
Thank you, Your Honor.
Mr. Eggleston, you may proceed.
Thank you, Mr. Chief Justice, and may it please the court. Before turning to the grittier details of statutory interpretation, I think a few preliminary remarks are helpful to give context to the current posture of this case. When the governor first filed this action for declaratory judgment, as well as in her opening brief, she purported to seek a limited declaratory judgment to, and I'm quoting the opening brief here, bring judicial standards during the COVID-19 pandemic back into the Jacobson framework and its progeny. She argued that the interest of protecting the public health during an emergency remains the paramount consideration for the application, the continued application of Jacobson. However, as the case presently stands, the governor is advancing a significantly broader view of her own power. She now contends that the Organic Act, which the people of Guam have no power to amend through their elected representatives here, vests ultimate authority and governance over and regulation of quarantine in the governor of Guam. By this, the governor, I understand the governor to mean that she has a constitutional authority to detain individuals or groups of individuals for an indefinite period, as long as that detention can be generally characterized as a quarantine. And that the legislature of Guam does not even have the authority to establish the standards by which quarantine decisions are to be made.
But Mr. Abelston, doesn't the process of the Organic Act giving court review create a check on the exercise of that power?
I'm sorry, you said the provisions of the Organic Act?
The general provisions of the Organic Act, doesn't it give the courts of Guam a check on the exercise of that power by the governor? You seem to suggest it's totally unlimited.
Well, and I think the governor takes the position that it is limited only by the Jacobson framework. And although we disagree about how Jacobson should be read, I believe that it is a standard, straightforward, rational basis case. The governor actually believes that it says that even the principles embedded in the Constitution need to be relaxed when the governor can point to an emergency. So even when an individual has recourse to a court, the governor's position would mean that they have very limited law upon which they can rely in making their arguments to the court, especially because if the legislature has no power to define the standards by which quarantine decisions are to be made, then in determining whether a quarantine of a particular individual is lawful, the court really has only the Jacobson framework that the governor, as articulated by the governor in her view, and the standards that the governor herself sets forth for the quarantine. And it's fair to say that that's not a check because the governor gets to define those standards.
Well, the standard in 1421 GA is for the protection of Guam against the importation and spread of disease. So if there's a quarantine requirement that doesn't provide or have any rational basis to protection against the importation and spread of disease, then the governor will not have exercised her power appropriately.
And I think with respect to rational basis scrutiny, that standard is such a permissive one. It is hard to imagine that a quarantine of incoming travelers could ever be found not to have any rational basis to the prevention of the importation and spread of disease, since there is always at least some and some plausible possibility that individuals outside of Guam are bringing in diseases that don't yet exist within Guam. Indeed, the yearly flu could be an example of a time when the governor could impose a quarantine, and that would cover at least half of every year.
But how do you reconcile the powers of the governor, as was pointed out by Ms. Travis, that are contained in 1421 GA, where you have the Bordallo versus Baldwin case that basically talked about the governor's power under the same provision dealing with hospitals. And then you have the subsequent amendment to the statute, the 1421 GB, where they changed in the public educational system took away the powers from the governor and gave it to the government of Guam. So doesn't that suggest that the governor has the powers that are set forth in those sections? Because how do we reconcile Bordallo v. Brown to get to a place where we say the governor doesn't have this power over the quarantine and sanitary regulations set forth in the Organic Act?
And I believe that the reconciliation of Bordallo v. Baldwin is actually at the core of the issue here, because the governor, although framing her argument as one of separation of powers, it is not separation of powers. Indeed, her interpretation of 1421G is that Congress actually chose a subject matter around which it was going to unify all powers in a single branch of government. So essentially, under her reading of 1421G, there's not an executive power over quarantine and a legislative power over quarantine and a judicial power over quarantine. Rather, there is just the ultimate authority over quarantine, which she contends is vested in the governor. Well, of course, if one takes as an assumption that that ultimate authority is an indivisible one, then it would make sense to read the statute as choosing the governor as the person to hold it. However, the separation of powers itself assumes that the ultimate authority over any subject matter is divisible into separate powers. And so I think that that's why it's important.
But wouldn't that just make then the language in 1421GA surplusage? You know, because I know your argument is that it doesn't require any more authority on the governor than what's already provided by 1422. And so it doesn't give her any further rulemaking authority beyond that's already given her under the powers contained in 1422. So doesn't that mean, and we shouldn't read statutes in that manner, if you're saying that it doesn't give her any other authority than what's contained in 1422?
That is true if the only potential effect of a statutory provision is as a grant of authority. However, I would contend that this is not surplusage for the simple fact that it imposes a duty where no other statutory provision within the Organic Act imposes that duty. It is possible for the governor to violate that section through inaction. It is not possible for the governor's inaction on quarantine to violate any other provision of the Organic Act, unless the legislature passes a law that the governor fails to faithfully execute. And I think that actually is the fundamental purpose of that section. And it makes me recall the only thing that I think I remember from CPR class was our instructor's directions on how to make sure to get someone to call 911 when there's an emergency. The one thing I remember her saying is, don't look up and shout to the room in general, somebody call 911. Rather, look up, find someone, it doesn't matter who, point at them and say, you, call 911. When you want to make sure that something gets done, you need to pick a person and say, do it. I don't think that requires reading the provision to also say that the legislature can't tell the governor how to do it. I think it simply is saying, governor, you need to act without waiting for enabling legislation.
What about the relationship of 1423A, which limits the legislative power to subjects of legislation that's not inconsistent with the provisions of this chapter and the laws of the US applicable to Guam? The governor argues that also supports the fact that since 1421GA is a law of the United States applicable to Guam, that the legislature has been limited by 1423A because from passing a law that's inconsistent with that power. What are your thoughts on that?
It bears noting that the Organic Act, as originally passed, set forth the legislative power in Section 10, and it said, the legislative power of Guam, except as otherwise provided in this act, shall be vested in a legislature, which shall consist of a single house. It said that the legislative power of the legislature itself was limited by the terms of the act. It therefore contemplated, at least potentially, that legislative powers could be vested elsewhere. However, in 1966, Congress amended that section to make it read that, let's see here, the legislative power, the legislative power and authority of Guam shall be vested in a legislature, and therefore all legislative authority, to the extent it exists, is vested in the legislature, but says that the legislative power may be limited by other sections of the act. That is, the act can limit the legislative power of Guam. It can place subjects outside of legislation, but it, as amended, it no longer allows vesting of the legislative power in a branch other than the legislature itself. And that is the basis for our contention in our supplemental brief, that to say that a particular subject matter falls within the legislative power of Guam is necessarily to say that it falls within the legislative power of the legislature. And that actually brings me back to Bordallo v. Baldwin, because I think the governor is conflating two essentially different things. What was at issue in Bordallo v. Baldwin was the executive authority over the operation of hospitals. And as we all know, no individual could independently and by themselves operate a hospital or public school system. The primary way in which the executive power is exercised is in the choice of those to whom the executive power is delegated. That is exactly the power that the legislature purported to take away. It purported to remove the executive power over hospital governance. Nothing in Bordallo or in any of its progeny purported to say that the legislature could not, if it so chose, dictate in minute detail the manner in which the governor is to operate the hospitals of Guam, as long as the governor is the one operating them.
Mr. Eggleston, if you look at the amendments to the Organic Act from 1986, that's exactly what they did. They took the power of the governor to appoint the Board of Education, the Director of Education from the governor, and vested it in an independently elected Board of Education that chose the director. And as a result, if you contrast the need for an amendment to change the education system, the fact that this provision with respect to public health wasn't amended seems to me that the Congress intends the governor to have absolute power. And there have been times the governors said, I'm running the hospital, it's in crisis, I'm taking over, and done it. So I'm concerned about the history of the amendments to the Organic Act seem to be entirely inconsistent with the argument you're making.
With respect to the legislative history of the 1986 amendments, I believe the governor already cites the Senate report on those amendments, but I think more telling is the Senate hearing from the Committee on Energy and Natural Resources, the actual transcripts of the hearing from which that Senate report was prepared. That is, and I would direct the court's attention to it, it is Senate hearing 99-515. And I think all of the testimony that the committee heard makes very clear why the amendment to Section B is intended to enable the legislature to do something fundamentally different than pass legislation micromanaging the public school system. I believe that it would be completely consistent with Bordallo for the court to, or for the legislature to leave the executive power in the governor, but specify in minute detail how to exercise that. But what the testimony in the Senate hearing established was that the issue the public school system was facing was that it did not have enough independence from the political system. From one governor to the next, major policy decisions, say what to teach, could get changed. And what the legislature wanted to do was not set forth in detail exactly what's going to be taught. What the legislature wanted to do was create an independent board, a board that could make those sorts of discretionary decisions independent of political pressure. The reason that the amendment was necessary is that normally the legislature could create such a commission under the provision in the executive's power that says that the appointment power can be limited by the laws of Guam. However, the Bordallo court, I think, correctly recognized that where the executive power, where the statute specifically directs that the governor is to exercise the executive power with respect to public health services and public education, that appointment power, which is the heart of the executive power, cannot be removed from the governor and placed in an independent commission. So it's precisely to allow that the 1986 amendment was passed with respect to the public school system. No such amendment was necessary for the public health services because questions like how to balance individual liberties against the need for public safety should not be removed from the political process. That's precisely what the political process is for, to make decisions regarding the interests of the community versus individuals' liberty interests.
Let me ask this: Can you envision a situation where the legislature passed quarantine regulations that essentially just made the governor's duties ministerial? And what would your position be on their ability to do that?
So I think there is a sense in which one could say the extent to which a governor's duties are ministerial is always going to be directly proportional to the level of specificity of the legislation that the executive is charged with executing. But we don't say that in a constitutional sense, that means it is ministerial. There's no ceiling to how specific legislation can be when the executive is tasked with administering it. And that's what's fundamentally—
Mr. Eggleston, wouldn't that be in conflict with the language that to establish, maintain, and operate if it's only ministerial? I don't see how you could then view it as not being in violation of the governor's powers to establish, maintain, and operate that is contained in 1421 GA.
And I think a good analogy here is to the prison system. Although that's not specifically mentioned in the Organic Act, I don't think that there's any question that it is an executive function to establish, maintain, and operate a prison system. But it is not considered inconsistent with that statement to say that it is the legislature who decides who shall go to prison, what acts will lead to a term of imprisonment, how long the term of imprisonment shall be, under what conditions parole shall be granted. And I believe that it would also be consistent with that for the legislature to specify in minute detail how the prison is to be operated, how many people would be in a cell, how many square feet. And indeed, the Bordallo court specifically said that the legislature could decide whether there shall be a hospital and where it shall be. Now, if clearly, the court considered that not to render the governor's function of establishing the hospital ministerial, and yet that is really, those are the essential choices regarding the establishment of a hospital. Shall it exist? If so, where shall it be? I think that what that recognized, though, is that it left the fundamental execution of the policy dictated by the legislature in the governor, or that's where the statute, the Organic Act, leaves it. What the legislature wanted to do was dictate not only whether there should be a hospital and where, but it actually wanted to, or not to dictate that, it wanted to choose someone other than the governor and delegate to that person those decisions.
Now, Mr. Eggleston, because your time is winding down and you didn't have the opportunity to respond to the briefing of the Amicus brief, I'd like your observation in terms of the Attorney General's position that 19604 and 605 is organic only when it's interpreted as intelligible principles and judicial review procedures and not as judicially enforceable regulations. So what is your thinking on that that argument in reference to the organicity of 19604 and 605?
I believe that the standard of, or the mechanism for judicial review described in the Attorney General's amicus brief is precisely what would control if sections 19604 and 19605 did not exist. That is, individuals could still seek judicial review pursuant to the administrative adjudication law, and they would be subject to the legal standards set forth in that framework. However, this court has said that it is not a knee-jerk reaction to wholly incorporate those standards whenever an enabling statute provides for judicial review. Rather, when the statute itself can be interpreted to provide the standard of judicial review, that governs. And so on the matter of the just statutory interpretation and standard of review, I think the question is how 19604 and 19605 are interpreted, not how these actions would look if brought under the general administrative adjudication law. With respect to whether...
But now that you've raised it, even if 19604 and 19605 survives a constitutional challenge, why wouldn't the standards under the Administrative Adjudication Act still be relevant and applicable in guiding the trial court how to resolve the application of the 19604 principles?
Well, this court has said that when a statute's language regarding the right of judicial review can be read as implicitly incorporating those standards, the court will do so. However, there are several good reasons to think that that is not the case here. First, the Emergency Health Powers Act is based on a model act that does not necessarily assume that there exists a completely separate standard that could be incorporated. Therefore, this language, it does not make sense to interpret as implicitly incorporating an outside standard. The Model Act was intending to set forth a self-contained statute. And that's why the statute itself can and should be interpreted to contain in its own language the standards to be applied. Secondly, the statute explicitly, at least in the case of 19605B, not only states a general legal standard, but an evidentiary one. It says that the court shall grant the motion for quarantine if the government shows by a preponderance of the evidence that it is reasonably necessary. And finally, the provision allowing for judicial review when an individual wants release from quarantine, the individual is able to petition the court for an order to show cause. Therefore, it clearly envisions that the order to show cause will be directed to the other party, the Department of Public Health, who would then need to come forward and bear the burden of showing cause why the individual should not be released from quarantine.
As I understand the AG's two-step process, I don't think the trial court would get into that type of detail in the second step, so long as the initial regulation passes the first step, that it is not in contravention of the governor's Organic Act authority.
Because we've not had the opportunity to brief the issue, I would assume for purposes of responding that if an individual were to bring an action for judicial review under the administrative adjudication law, I will simply assume that that is a correct statement of the standards that would apply to such an action. But fundamentally, that is not what individuals are bringing. They're bringing actions under 19604 and 19605, which for the reasons that I just mentioned, cannot and should not be read to implicitly just adopt wholesale the standards that would be applied under the general administrative adjudication law. And the reasons, and that should not come as a surprise, because unlike your usual administrative proceedings, these matters involve the fundamental issue of an individual's liberty interests. They're being held and detained on just an executive order. It would be unusual if decisions of that nature were subject to the same deferential review that an administrative regulation of a business, how a business utilizes its assets would be subject to review.
Well, Ms. Travis asserts that that's a standard that is in effect in most jurisdictions across the US, is the executive through an executive order is setting forth some restrictions, and that the Jacobson case is used to analyze whether those restrictions are appropriate and constitutional.
And we do disagree with that reading of Jacobson. I believe that Jacobson involved the straightforward question of, does a state, and of course Jacobson assumed that as a matter of state law, the legislature had in fact delegated authority to the state city council to make this decision. So the question was, does the state have the power to mandate that a person be vaccinated? And it should come as no surprise that a question like that receives only rational basis review. There's no provision of the Constitution that would implicate a heightened standard when that question comes into play. And the court simply said, yes, it's rational, therefore it's constitutional. I just don't think it applies here.
The Attorney General also points out when it's talking about its two-step analysis that the Chief Justice asked about, and saying in the second step of the judicial review, basically the review is only going to be focused on whether the regulation should still apply. The Attorney General suggests that an individual should not be entitled to claim individualized quarantine measures to be effective in their case, and that having individualized quarantine measures run counter to the idea that you're going to have rules and regulations govern quarantine. What is your response to that?
My response is that if the legislature were to pass a law saying that all incoming travelers to Guam shall be quarantined for 6 days, that would very likely be subject to rational basis review. And to the extent that that statute did not provide for an individual to ask for individualized consideration for exemption, then none would be available. But in this case, the statute itself allows individuals to seek judicial review of whether they should be released from quarantine and whether the conditions of quarantine set forth in the statute have been violated.
But how would you reconcile that with the governor's power over quarantine if she had a different rule than what the legislature passed?
I would reconcile that by saying that 1421G is in order to exercise the executive authority already granted in the section setting forth the governor's powers, but it is not an independent grant of legislative authority. And to the extent that it is a concurrent grant of legislative authority. And when there's a conflict between legislative acts of the legislature and legislative acts of the governor, it is the legislatures that control, not only because the governor's authority is limited to regulations not inconsistent with applicable law, but also because section 1421G specifically says that the governor's operation of quarantine shall be subject to the laws of law. If there are no further questions, it looks like I am out of time. Thank you, Your Honors.
Thank you, Mr. Eggleston. And now, Attorney Wampet Borja, you are recognized.
Thank you, Your Honors. Ana Wampet Borja for the Guam Legislature. The 26th Guam Legislature enacted the Islan Guahan Emergency Health Powers Act, finding that Gov Guam required extraordinary powers to respond to public health threats such as COVID-19, but such powers are not limitless. The EHPA and the quarantine provisions at issue in this case must be seen for what they are: reasonable provisions that empower the governor to rapidly and efficiently contain public health emergencies. The governor has not met her burden, showing that quarantine provisions are inorganic. The legislature will demonstrate that the quarantine provisions of the EHPA are lawful exercises of its power for 3 reasons. First, the plain language of section 1421GA, subject to the laws of Guam, means that the legislature shares power over quarantine. Second, the Ninth Circuit's analysis of section 1421GA demonstrates that just as the legislature maintains concurrent authority over the hospital, it maintains concurrent authority over quarantine. Third, the legislature submits that the quarantine provisions are lawful exercises of its police power and do not impinge on the governor's quarantine authority because they do not prevent her from accomplishing her duties. Moving to my first point.
Ms. Wampet, one of the, in your brief, you said that the governor had mischaracterized 19604 and 605 as quarantine regulations, and they impinged on her authority to promulgate them. And you said they're not regulations because they're statutes, but it can't be as simple as that. I mean, it can't be just simply because the legislature passes an act and then therefore it's a statute and not a regulation, controls whether or not the governor's power is impinged. Can you envision a situation, or can you give me an example where you believe the legislature would pass a law that would infringe upon the governor's authority to promulgate quarantine and sanitary regulations?
Well, in this scenario, we argue that 19604 sets baseline provisions, reasonable conditions, a framework from which the governor can operate her quarantine policy. So for example, if the condition that stating that a person is entitled to adequate food instead stated that a person is entitled to 4 meals a day, vegetarian 5-star courses, then that kind of detail perhaps is in conflict with what Berdalio states. And so we do not argue that the legislature's power under section 1421GA is limitless either, but that it's a concurrent power, and that 19604 and 19605 are reasonable exercises of that power. And if we look to the plain language of section 1421GA, it states in relevant part that subject to the laws of Guam, the governor shall establish, maintain, and operate public health services in Guam, including hospitals, dispensaries, and quarantine stations. If we apply the plain meaning rule and give effect to every clause and word in section 1421GA so that no clause is rendered superfluous, it follows that the legislature may enact quarantine laws to which the governor is subject. This is consistent with the case in Berdalio versus Baldwin, which directly dealt with the parameters of the legislature's power with respect to the hospital. Applying Berdalio to this case, then the legislature may determine whether a quarantine station shall exist at all, whether and how large it shall be, the size and qualifications for appointment to the governing body, and the legislature can determine a wide variety of other matters establishing the laws of Guam, subject to which the governor performs her function. Unlike Berdalio, where the law at issue there allowed a privately selected board to exercise all powers vested in the hospital, the quarantine provisions here do not take over the entire field. 19604 and 19605 are broad mandates, and the governor may make detailed decisions and govern over quarantine, and she has in this case. Thus, the quarantine provisions leave room for the ultimate responsibility to remain with the governor. The case in Brown versus Civil Service Commission is also persuasive because it interpreted subject to the laws of Guam in Section 1421 GA as meant to apply equally to the public health system and the public school system. The court in Brown examined the legislative history of 1421 GA and B at the time of enactment, finding that it did not indicate that Congress intended to give the governor exclusive power over the public school system. It follows that because the clause subject to the laws of Guam is express in Section 1421 GA, the governor does not hold exclusive power over quarantine. The governor uses the testimony from Brown and the 1986 amendments to 1421 GB to argue that her power is exclusive. However, we submit that regardless of the 1986 amendments to 1421 GB, Brown tells us that when 1421 GA was enacted, Congress vested the legislature with concurrent power over public health and public education. Finally, the quarantine provisions are lawful exercises of the legislature's police power, and they do not impinge on the governor's quarantine.
Before you proceed, just that last part of your argument that Congress had recognized 1421 GA as having concurrent power with the legislature, and why then, and the language of 1421 GB before the amendment had similar language, and why was it necessary for the Congress to amend that in order to affect the governor's powers over education and to then seemingly authorize the legislature to have this concurrent power in allowing it to affect how the education is operated. So I mean, it just goes back to Attorney Travis's argument. I mean, if this wouldn't have been necessary, if in fact the language did not suggest the governor's plenary power in 1421 GB as it exists in 1421 GA.
At issue during the 1986 amendments to Section 1421 GB was Guam and the legislature's attempt to allow a shared power over the executive function over public education, and to allow a board to have a role in the executive function. So we submit that the amendment of changing governor to government did not exclude the legislature from having a role at all. The governor does not point to the final iteration of the public law of those amendments where Congress inserted the language at the end of that sentence to read according to the laws of Guam. So the legislature's role over public education is maintained in that respect. While now the government and government officials share an executive role over public education, that role is still subject or must be carried out according to the laws of Guam. Finally, the quarantine provisions are lawful exercises of the legislature's police power, and they do not impinge on the governor's quarantine authority because they do not prevent her from establishing, operating, or maintaining her duties. As we know from Gale versus Guam, the police powers of the legislature, the police powers of Guam rest with the legislature, and sections 19604 and 19605 are reasonable exercises of this police power. The
But
governor here.
Ms. Wampat, aren't the police powers limited by the creation of the governor's special authority over quarantine? Hasn't
Yes.
the Congress carved out an exception from the legislature's general police power?
Congress has allowed for Section 1421GA to be a shared power, and in exercising the legislature's police power, it must exercise some restraint. And we think that here, sections 19604 and 605 show that kind of restraint, given that the governor still has wide latitude over quarantine to determine, for instance, whether the quarantine stations be at Pacific Star or Dusitani, whether or not they are free or government funded. She has determined how to allocate resources to quarantine and how to staff facilities.
But what if the legislature, for example, decided to follow other island nations of Oceania and passed a law that said the borders of Guam are closed? Would
Then we
that
think
be a
that-
usurpation of the governor's authority, even though that could be deemed an exercise of police power?
We don't think that it would, but it would depend on the particular issues in that, those particular facts presented in that case. But together, the legislature's lawmaking power, its police power, its power under 1421GA over public health services generally, and quarantine stations all support how the legislature acted with this in this respect. The legislature, of course, must exercise restraint, but we argue that it's consistently acted within the bounds of the Organic Act and within the parameters articulated in Bordalio. Thus, the legislature requests that this court uphold section 19604 and 19605 of the EHPA as valid exercises of the legislature's inherent power to protect the health, safety, and general well-being of the people of Guam during this public health emergency and the next. Thank you.
Ms. Wampat, let me ask you, I know the legislature did not want to take a position in its brief as to the appropriate standard that applies in determinations for relief under the EHPA, or whether the Superior Court misapplied the law. But doesn't 19605, which is a legislative act, contain standards that appear to require, and you took the position that you have the authority to give the court under your authority to grant jurisdiction to the court over statutory claims, to be able to give the court that authority to make that determination. So aren't we required to analyze the grant of that authority, and in terms of how it impinges upon the governor's abilities to promulgate quarantine regulations?
Is your question, are you required to determine what the standard is to determine whether?
Well, I mean, it seems like the legislature has set forth the standard, and then you, in your briefing, you said, well, we don't want to take a position on what's the appropriate standard. So it seems to me that if you've set forth the standard that you feel should be followed, shouldn't that be the standard that you're advocating for? And how can you say, well, we're not going to take a position and that's an appropriate standard, even though it's contained in the law that we passed?
The legislature did not take a position only because the particular standard of judicial review and how the governor had characterized the standards as not clear standards instructed or applied by the Superior Court doesn't in and of itself render 19604 and 19605 as inorganic. And so using the principle that the statute itself is presumed to be constitutional, then we didn't think that it was necessary to go so far as to instruct what the standard of review should be and how a court grants statutory relief. But certainly the standards or the principles applied in sections 19604 should themselves limit how a court reviews an individual's claim for statutory relief, as well as determining whether or not public health acted and consistently with the law as the legislature provided.
Attorney Wampat-Bora, I want to go back to Justice Merriman's hypothetical, because I wanted to try and get some sense of this concurrent jurisdiction and the potential limits. So as Justice Merriman asked the question, if the legislature was, assuming that the governor has the power to close the borders, but if the legislature passed the law that says before the governor decides to close the borders because of pandemic conditions, it must obtain the consent of the legislature, and assuming they set up the process that this can be expeditiously decided, would that be within the power of the legislature to legislate under this concurrent jurisdiction, or does that unnecessarily interfere with the governor's powers under the Organic Act in reference to managing quarantine conditions?
Section 1421 GA gives the governor specific functions to establish, maintain, and operate public health services and quarantine stations to prevent against the importation of disease. So if the legislature were to, in using its concurrent authority to determine whether it was safe or unsafe to restrict travel to Guam, that it appears to be a broad authority that is in line and consistent with the Organic Act and the legislature's inherent police power, provided that it is not dictating the particular ways in which the details that the governor may enforce that law. So as long as the executive is not prevented from administering that law, promulgating regulations pursuant to that law, as long as she is consistent in applying that law, we don't see how there is a conflict and that the legislature is not empowered to do that under the Organic Act.
So you're saying that the power to close the borders is not taken away from the governor. It's not necessarily just a ministerial act, but just that there is a process, and that process, the legislature is authorized to legislate under this concurrent interpretation of the Organic Act.
Yes, and that's consistent with the separation of powers doctrine and the balance that is struck here with the EHPA. Otherwise, if we are granting the governor exclusive authority over public health services generally, for instance, we would be stripping the legislature of any say over public health policy, and for allowing the legislature to define the jurisdiction of the courts to also play a role pursuant to that policy. And that would just open the door, we think, unnecessarily to take away the legislature's power that is traditionally understood to be within its purview.
All right, I see your time and more is up, and so I thank you for your arguments. And at this time, I will recognize Assistant Attorney General Jordan Pauloon.
May it please the court. My name is Jordan Pauloon, and I'm appearing on behalf of the Amicus, the Office of the Attorney General of Guam. I first want to start by acknowledging the massive inconvenience the pandemic and COVID-19 has brought in everybody's lives, including the quarantine facility that applies to travelers and those testing positive for COVID-19. However, measures like that have allowed Guam to stop the spread and slow the transmission of an infectious disease that just yesterday claimed its 139th life in Guam. On that note, I want to go to fundamentally the question that brought us here in the first place. We've talked a lot about the legislature's role in enacting the policies here, but let's not forget that this case started as a dispute between the governor's power and that of the quarantine court, and the standards of review that are applicable and the deference that is owed to the governor and the politically accountable branches when it comes to making public health policy. It is the position of the amicus that that type of deference, had the traditional deference and the deference owed both under the Organic Act and the Emergency Health Powers Act, was not properly given to the governor during the course of this dispute. The Emergency Health Powers Act, if interpreted in the manner that the Superior Court and the public defender have been advocating, it would result in an inorganic interpretation as suggested by the governor's office. However, in my brief, I go through a saving construction in which this court can interpret it in a manner that does not violate the Organic Act and can, while still providing the deference that is owed to the governor, given that she is principally committed under the Organic Act with the public health powers over quarantine and sanitation.
Mr.
Governor,
in terms of the saving interpretation, as you refer to it, you suggest that 19, 604 and 605, if read as intelligible principles and not read too rigidly or treated as specific regulations, then would not encroach on the governor's Organic Act powers. But if they are read too rigidly or treated as regulations and not as you call them, intelligible principles, they would encroach. But the intelligible principles doctrine, as I understand it, looks at whether there's a forbidden delegation of legislative power towards a legitimizing agency. Isn't our inquiry here focused on the separation of powers issue between the legislature and its encroachment on the power of the government, and not really directed towards the legislature's delegation of its authority?
I agree that oftentimes the intelligible principles doctrine does come up, especially in federal case law, related to the delegation of legislative powers to an agency to make rules and regulations. Here, though, that same doctrine would still have relevance, because in this case, the United States Congress in the Organic Act has delegated rule-making power over quarantine and sanitation to the governor. And the governor's office goes to
so you're talking about it in terms of delegation from the Congress to the governor and not from the legislature to public health.
Yes, but the governor acts through public health, and so we are talking about it primarily, though, in the terms of the governor's power, which is what presents a certified question in this case, is about the governor's powers. And but the governor does act through its appointed officials in the form of public health. So the intelligible principles, though, would be those that the legislature is entitled to suggest, but that is then an issue of principles between the governor and the legislature. Instead of using those as principles for regulatory making, the Superior Court has, in the quarantine cases, was going in and applying them as specific mandates to order people released or relief on different bases that were essentially substituting the judgment of the governor and the public health authority. And so that's the real concern that got us here, was that lack of deference. And the public health brief that was submitted in this case, as well as the second half of the amicus brief, go through those standards of deference and how they should be applied in this case. You
state that the quarantine court should have only reviewed those regulations or the actions for an abuse of discretion. And then you talked about whether the analysis should only be whether regulations still apply. Is that?
Yes, let me give an example of this two-step approach that it puts it in a really simple form. If we take an example of, for isolation purposes, the governor and public health promulgate a rule that says if you test positive for COVID-19, you are subject to isolation and that you shall be isolated in a facility. That regulation bears a rational relationship that I don't even think many people would credibly challenge in court, that it has a rational relationship to combating the pandemic and going to the governor's authority under the Organic Act, and that purportedly applies in 19604 and 19605. But then let's say we have a circumstance where the governor's office comes in and tries to quarantine somebody through a mistake or whatever that has a negative test for COVID-19. In that case, the person could go to court to challenge the facts on step 2 that exist for their actual quarantine. They can say, I have a negative test, I never tested positive. And so in that case, you would order their release. But when it actually comes to the regulations and the length of time for quarantine and who's subject to it, those are decisions that are principally committed to the experts at public health and in the executive branch. And for the court to come in the midst of a pandemic and start second guessing those in orders and other things is a very tenuous and sometimes and a practice that can sometimes yield dangerous results. And so, that's a very simplistic example, but there is this two-step process. An individual can come and challenge the regulation, but as public defender even pointed out, there's very few instances in which that challenge is going to be successful. And that is precisely because, as even Chief Justice Roberts had stated in the South Bay in his South Bay concurring opinion, we principally commit those decisions to the politically accountable branches and our public health experts. And so if there is any rational relationship between the regulation promulgated by the governor's office and or public health, the regulation to the public health emergency and the prevention of the spread of COVID-19, that regulation should survive judicial review, full stop. Then the thing is, when somebody actually is subject to that quarantine order, the question for the court is, do the facts exist that put them within the purview of that regulation? And they can challenge that the facts don't exist, such as they never tested positive in the example that I had given. But once public health or the governor establishes that the facts exist that bring that person within the purview of the regulation, such as they were an arriving traveler for a lot of the cases that have been going on, the analysis is over. The person is subject to it, and we go with the regulation. The politically accountable branches are where those disputes are had, and we don't go through and we don't have the court come in and make individually tailored quarantine policies unique to each individual. That's, in a pandemic of this size, it's impractical, but it runs counter to the idea that we treat similarly situated individuals the same under the law. And so the position of the Attorney General's office is that we can interpret 19604 as broad principles that the legislature says, here, governor, go look at these. But then that's between the governor and the legislature, and that doesn't leave room for judicial review of politically accountable executive decisions.
So what about in the instance where someone who is quarantined and now is of the position that he or she should be released from quarantine, and that they are no longer pose a risk. And would they be able to file an action to challenge that, or is it that the regulation that says, well, you got to stay in there for 14 days, and assuming that it's not the 6th, 7th day, and because that is what the science says, you need to remain quarantined. And so, in the first instance, it was found that the regulation is valid and proper, but in the second step analysis, where someone feels that they're entitled to be released under 19605 because they no longer pose a risk, they're precluded then, you're saying, from making those challenges.
I think they are precluded from making those challenges specifically. I will not say that they have no right to file a petition in court and seek review of the decision, because that's, as public defender points out, there's a right to access the courts, and we never want to close the courthouse doors on somebody. But then it comes back to the question of what the judicial role is when somebody actually enters the courthouse doors, and the judicial role is a very limited one. If we're dealing with a policy,
then the trial judge in that instance, and just following up on that hypothetical, will then is compelled to say that because the regulation in the first instance was found to be valid, and therefore I am compelled to rule in favor of public health, and end of case, although you've allowed them to file the case.
Yes, that is correct. And I think that's because the risk determinations and the risk of infectiousness, those are the decisions that we commit to the experts. And that are not committed to the judiciary. As sympathetic as an individual litigant may be, our system commits those decisions to the public health experts and the politically accountable branches. The risk determination.
What about actions for remedies regarding breaches to the conditions of isolation or quarantine?
Yes, and I think that raises a very good question. The conditions, as the legislature has laid them down in 19604, are actually they're really generalized principles, and they require inadequate means of communication. However, in some of these cases, the Superior Court has been going in and ordering specific quality of internet for families because of educational needs. It does, we still commit those decisions to the public health as to providing an adequate means. If they're not providing an adequate means, you can come in and get review of that, but you don't get a different adequate means of communication just because it's a different case. It should be the same for everyone, absent if you're giving, absent some sort of disability or reasonable accommodation that may need to be made. It needs to be the same for everyone. And so public health can't be required to predict whether somebody coming in is doing online school or needs something for this or that. It's the ability to provide inadequate means of communication, which is primarily for communication with their attorney and potentially their family about certain needs. It's not supposed to resume life as normal when you're in quarantine. It is an inconvenience, and we recognize that, but it's a necessary one in public health's determination that they've made based on the science and the circumstances on the ground in Guam.
I'm a little puzzled by your argument, because it seems to me what you're saying is the court is unable to apply the standards set forth in the law. And does that mean then that you agree that those particular sections exceed the authority of the legislature to set the standard of review for the court?
I think as it relates to the court, yes, but I also don't even read them in the first place as judicially enforceable standards of review. I read them as standards for the regulations themselves. And all the regulation then has to do is bear any rational relationship to the Organic Act and or emergency health power standards, which in almost every case, we're going to defer to the executive branch and the experts therein when it comes to determining the validity of that regulation under the Organic Act and Emergency Health Powers Act. That doesn't mean that the court can't review it, but the court's review, as they've done in many other agency actions, is a very deferential review of that regulation. And absent, the best example I use is it's kind of like roads and cars. If we're talking separation of powers here, it's the executive branch that gets to drive the car. The judiciary is really the curbs on the outside that keeps people from going way too far outside. But in a lot of cases,
it seems to me that you're going back to the constitutional standards that Ms. Travis was talking about. The only way the court should act is if someone's liberty has been improperly taken. And these things that are set forth in 19605 don't really matter. We should go back to, has an action of the executive branch impinged someone's liberty too much? And therefore there needs a correction done by court order. And it doesn't matter whether there's another way to assist the traveler or something like that, as might be suggested in the legislation.
So, and I think this comes back to the same deference issue. I agree that there are problems and inconvenience, but we're also not talking about a long-term, indefinite, arbitrary and capricious detention here. We're talking about a quarantine order that has been specifically tailored by the experts based on the science and the circumstances that exist on the ground. And so in those contexts, by and large, the vast majority of the science suggests that a 14-day quarantine is what's necessary to eliminate the possibility of spread completely. There's general scientific consensus on that. I think in the instance that the governor were trying to quarantine people for 50 days to prevent the spread, the court could come in and say, yes, that's arbitrary and capricious and bears no relationship to the science. The facts don't exist to support that regulation. However, in the instance that the experts and the executive branch have carefully considered the facts and circumstances and applied it in making their regulation, they are entitled to the deference by the judiciary, because these are decisions for the politically accountable branches. And I think Ms. Travis's argument related to the power of the governor over health and the power of the government over education highlights this, that in the context of public health, the Organic Act even dictates that we should defer at a higher level to the governor than we do in other circumstances contemplated by the Organic Act. And so for that, 19604 really needs to be generally read as intelligible principles that are not standards of review to be applied by the court.
But the corollary of that is that if they're not, and as argued by Attorney Wampat Borja, that there are statutory provisions that invoke concurrent jurisdictions and are subject to be enforced under those standards, then it's your view that 19604 and 605 are inorganic.
Yes, they would inorganically encroach upon the governor's authority to regulate.
All right. Thank you, Attorney Paldun. And you're way over your time. So at this time, I will recognize Attorney Leslie Travis. And Attorney Travis, because of the many arguments that were put forward, you'll continue to have up to 10 minutes on your rebuttal argument.
Thank you, Your Honor. And I apologize if I'm kind of jumping. I'm addressing different. I'm going to try to organize them in some sort of logical fashion. I want to start with addressing some of the arguments made by the legislature. Specifically, there was a question that was asked regarding whether there were any limitations on the legislature's police powers. Of course. The Organic Act specifically provides that the legislative power of Guam shall extend to all rightful subjects of legislation, not inconsistent with the provisions of this chapter. And I know that the legislature is interpreting 1421 GA to mean subject to the laws of Guam, gives them a blank check to enact whatever legislation they feel to balance out, I guess, to check the governor's authority under 1421 GA, but that's not appropriate because it specifically gives the governor that authority. And as Justice Torres pointed out earlier, if we were to read it in the manner interpreted by the legislature, that language would be mere surplusage. It really wouldn't be necessary at all because under the existing structure, the legislature passes laws and the executive branch implements those laws or executes those laws. So what is this? Why is it different? This isn't a stray Oxford comma in the Organic Act. This is a substantive, robust mechanism by which the governor is supposed to protect the public health of Guam. And if the legislature and the public defender are to be believed, we're just supposed to read this as normal course, nothing to see here. And we can't read it that way. We can't read it that way for regular laws, and we shouldn't read it that way for our constituting document. The issue of whether or not a public defender raised the issue of whether or not 1421 GA actually entails a duty versus a power. This is something that they addressed in their brief as well. It's concomitant authority. And the reason I know that, that's not my invention, that's in the Bordallo case. Bordallo held that the legislature has in effect taken over the entire power to establish, maintain, and operate the hospital by dictating who the governing trustee shall be. The governor is stripped of all power to have any voice in the policies, management, or procedures of the hospital, despite the mandate of the Organic Act to the contrary. So I understand that public defender wants to make this kind of a restrictive interpretation, and I believe that the legislature repeated that as well. This leaves room for the governor to exercise her ultimate responsibility to implement the legislature's laws, but it actually doesn't leave the governor any discretion. By the legislature's interpretation, the governor can't disagree with what the legislature wants the policy to be. The legislature has the ultimate authority, and that's wrong. We know that because Bordallo says it's wrong. The governor has the ultimate responsibility under the Organic Act. The legislature can pass laws, but they can't pass laws inconsistent with the Organic Act. The language that allows the legislature to pass laws that even affect this power is general. The grant of authority to the governor is specific, as plain canons of statutory construction. The public defender pointed out that in 1966, there was an amendment that vested legislative power only in the legislature. Bordallo was decided in 1980. I believe that Brown was decided in 1985, and Nelson versus Atta was decided in maybe a year or two later, 1986 or 1987. In all of these cases, and I understand public defender is going to say, well, executive power was really the issue in Bordallo. What about in Brown? What about in Nelson? These were powers over public schools, which I think a public defender would agree normally under normal circumstances, if we were a state, yeah, that'd probably be part of the legislative power of a state. But obviously in 1421 GB, everyone has interpreted that original language to confer that authority on the governor. It had to be changed to vest it in the legislature. Let's talk about Brown, Your Honors. The legislature submits that Brown actually says that there's concurrent authority between the governor and the government of Guam, the legislature of Guam, over public schools, that's what 1421 GB means. And Nelson versus Atta actually kind of clarifies that language. So Nelson versus Atta says, yes, that's true, but that's because the Organic Act of Guam specifically said that the legislature shall pass a merit-based system for personnel on Guam. So yeah, that affects public education as well. That applies to public education. And I would submit to your honors, this is another example of a way in which the legislature can affect quarantine, or the governor's quarantine authority here, is the employees of the governor's quarantine facility are also subject to the merit-based system passed by the legislature. They have that authority under the Organic Act of Guam, but they don't have authority to come in and usurp the governor's authority over quarantine. Ultimately, your honors, the legislature appears to be saying, and I don't want to put words in anyone's mouth, but my understanding is the argument is that this is shared power, but to the extent that there's a disagreement, the legislature's decision rules. And that
What
is
about the AG's opinion on 1604 and 1605 being just a guidelines or intelligible principles? You've indicated you don't have a problem with that if that's the interpretation.
That's with regard to 19604. 19605 actually limits the governor's ability to quarantine people for the period of time that she would like to. Obviously the circumstances are changing on the ground. The current policy allows individuals to test out after 6 days. However, there was a policy that was implemented in August in response to the spike in cases that required 14-day quarantine in the facility. So the 19605 requires that these individuals, that the government petition for the continued quarantine of these individuals, and gives the court the ability to release them from quarantine after 10 days, if the court so wished, and not subject to the constitutional review in Jacobson. So I think it's a slight disagreement with the AG's office, but in general, if 19604, if all that is a statement of what the legislature would like the governor and her ultimate authority to consider when she's generating her quarantine regulations, then I think 19604 is fine. We think that some of those ideas are great. We've implemented some of them ourselves in our very first policy. There seems to be this misunderstanding that the governor, I think one of the extreme examples used earlier is, oh, we're going to quarantine everyone for the flu every year. Well, Jacobson requires that it's tied to a public health emergency, and I don't know that the flu would be characterized at that at this point in time. And certainly if the governor tried to quarantine me for the flu, I might consider hiring the public defender's office, I guess, would be appointed to represent me. But the bottom line is there are checks to the governor's authority. This is not, she doesn't have carte blanche to do whatever she wants. She has ultimate authority to determine the quarantine policy on Guam, but she's still subject, as everyone is, as the legislature is, to the Constitution. Unless your honors have any further questions, I would just like to conclude by saying thank you so much for considering this issue. We think that obviously this is gonna control the future of Guam, and thank you for your attention to this matter.
Thank you, Attorney Travis. If there's no other questions, then this will conclude our oral arguments. And normally I would say that we will take the matter under advisement and the court's adjourned. But as we all agreed, this is an outreach for our Law Day activities. And so we will adjourn for purposes of this court case. But if everyone could remain back, and I see that we do have a number of questions that Justice Torres.
Yes, we do have some questions, Chief Justice, and I'll facilitate the asking of those questions that have been submitted by a number of students. And the first question will be directed to the lawyers, and maybe two of the lawyers in the room, in the virtual courtroom, can answer it. And the question is, why did you decide to become a lawyer? And maybe Brian, Mr. Eggleston, you can answer that question first, and then we'll ask the governor's attorney, also Ms. Travis, to answer that question.
Sure. I think actually my route to becoming a lawyer was probably different than a lot of people. I had no real interest in the law growing up. It was not until college that I decided what I really wanted to be was a philosopher. And I realized that that's doesn't have a lot of potential for having a real impact on the world. And so for me, law was the closest thing to philosophy that would still actually have me doing something other than sitting in a room with a cup of coffee, just opining on the state of the universe. So it was a way of thinking and an intellectual endeavor that had a real impact.
Ms. Travis?
Thank you, Your Honor. I had a much straighter route to the law. When I was 13, I watched my very first high school mock trial competition. My sister was playing for the team at Ocean View. And Justice Torres, you know this because we played against your daughters. I ultimately ended up playing high school mock trial for all 4 years. And then I ended up playing in law school, and I'm not coaching right now because the season has been suspended, but I generally do coach high school mock trials still now. So I knew I wanted to be a lawyer, and I knew I specifically wanted to be an advocate because of high school mock trial.
Let me ask this question of Attorney Canto, former Judge Canto. What advice do you have for someone who wants to become a lawyer, a student who might want to become a lawyer? Do you have any advice that you can give them?
Oh, thank you, Your Honor. That's a tough question. I would say that you'd have to cultivate a love of reading. There's definitely, I think everyone would agree, there's a lot of reading that is required of the job, and learning how to become a lawyer as well. And if that's something that you enjoy generally, and learning and being able to apply logical arguments to facts, then that's the way to pursue it. And also to continue reading about becoming a lawyer, if that's something that will help inform your choice and help you decide ultimately if that's what you want to do, because it is such a great commitment in terms of the length of schooling and the investment. So I guess the advice would be to learn as much as you can about the law. There are many different fields to practice, many different ways in which you can practice, and go to court, go see what happens in the courtroom. It's a public forum. And those are the types of things that can definitely inform you and hopefully help enhance what may be a spark at that point into a great passion for the law and eventually becoming a lawyer one day.
Thank you, Attorney Canto. Attorney Wampat, a question from another student is, how do you prepare, considering this is a long oral argument and an important issue? What did you do to prepare or practice for this argument?
Well, this was tough because there were a lot of facts in this case, a lot of law to digest, and many parties involved. So it was important to constantly read the record, go over our arguments, and honestly talk through them with other lawyers, and just keep throwing the hypotheticals around until you can wrap your head around your strongest arguments and your weakest ones, and do it over and over again.
Thank you. Attorney Pauloon, one of the questions is, what is an amicus, and why were you allowed to file a brief in this case?
So an amicus is actually short for the term amicus curiae, which is Latin for the term friend of the court. And in a lot of cases, especially cases before Supreme Courts or appellate courts, parties are allowed to seek permission from the court to offer some alternative views, because a lot of times the questions are have some broad significance and are applicable outside of just the case that's being argued. The government, though, and the Attorney General's office specifically, is an amicus that does not require permission and can file its own views in any case. And so the Attorney General's office weighed in with their brief in this case and the arguments there because of, in part because of the importance of the questions that exist here.
I'll ask this next question for either the Chief Justice or Justice Merriman, or maybe both of you could answer it. It's a two-part question: is why are there 3 justices instead of just 1 judge? And what happens if we don't all agree on a case? And actually a 3-part question: and how do we go about deciding a case?
I will defer to Justice Merriman in the first instance.
Thank you.
That's the power of the Chief Justice.
The number of justices that sit in either a Supreme Court or another appellate court is determined by the body that created the courts. So the United States has laws that govern how United States federal courts are set up. The Guam legislature created the Supreme Court of Guam with 3 justices, but it could just as easily have made it more. Usually there's an odd number. So we sit as a court of 3. And if 2 of us agree, then we write what's called the majority opinion. Most of the time in our court, all 3 of us agree. And then the one justice who may not agree with the other 2 writes a dissenting opinion. It's not usually as long as the majority opinion, but it explains why that justice disagrees on a point of law with the other 2 justices. And given the large amount of lack of civility in some of the other branches of government, I would say that when we disagree based on principles. It's not a personal disagreement and so we try and stay very close to the principles of law that we're discussing. Obviously, there's more than one opinion about these, or we wouldn't have the case. And sometimes one of us is not persuaded as much as the other 2 are. Finally, we decide the cases by doing what Ms. Wampat discussed. Before the oral argument, we do a lot of preparation. We read all the documents that are submitted to us. We look at other cases from other jurisdictions, and we think about what the implications could be of our decision. And then after the oral argument, we talk with one another in what's called a panel discussion. We work with our research attorneys, and we reach decisions about how we view the application of the facts to the principles of law that we find for the particular case. And then our most important job is to write as clear an opinion as we can about what happened and what our decision is, so that others may rely on it and advance the rule of law. I'll yield if the Chief Justice wishes to add anything.
Thank you, Justice Merriman. Not to that very complete response to the question, but I would like to touch on the question that was addressed to Deputy Attorney General Canto, just in terms of any advice to someone who's thinking to become a lawyer or wants to become a lawyer. And I want to point out the other side, that a lot of times, as I indicated in the beginning, that you watch TV, Law and Order, and a lot of times you see the glamour, the perceived affluence of someone in the legal profession. Everyone here looks, so properly dressed, and that it's a profession that's held in, at least to many of us, in high esteem. But there's also a lot of challenges, risks, and potential downside in terms of the profession. I never encouraged any of my children to become lawyers, although my oldest one, eventually is a lawyer, did become a lawyer. And they see a lot of the benefits, the fruits of a successful profession, or getting ahead in the profession. But it, as pointed out here, there's long hours in reference to doing this job very capably. There's a lot of sacrifices. There's also a lot of restrictions, standards, ethics that apply in the way that you do your job. And so while there are definitely benefits, it's an honorable profession. It's one that has a lot of challenges along the way from the very start, as Attorney Canto pointed out, in reference to how to become and what it takes and the rigors of the education to become a lawyer. But to me, it's really a lot of the temptations, a lot of the potential risk of falling short in what is expected, that you need also to have be aware in reference to the profession. It's a noble profession. It's a very rewarding profession, but you got to work at it constantly, daily, if you want to do a good job in the profession. And I don't know, just Doris, if that's all the question. Are we ready to close?
And one final question, and I don't think it's a prediction of the arguments in this case, but it's curiosity from a student. And that is, if the Supreme Court doesn't interpret the law in the governor's favor, is there anything procedurally she can do next? What's the next step? If it or for the same with the public defender's office, if the case is not ruled in their favor, is there anything remaining that they can do?
That's you, Brian.
So I think the answer with respect to this case being in the court's original jurisdiction makes it somewhat different than it probably would be in a standard appellate case. In an appellate case, and I have to apologize, I am not incredibly familiar with post-decision procedure yet, because this is my first case before the Supreme Court, and I've have yet to need to review such provisions. But at least in most courts of appeal, there is a procedure for seeking rehearing. It's often very difficult, and requests of that nature are often denied. But ultimately, after that, the U.S. Supreme Court does have jurisdiction to hear appeals from this court. And if a party believes that a decision was wrong and is important enough to merit the resources necessary to bring proceedings before the U.S. Supreme Court, then the non-prevailing party could file a petition with the United States Supreme Court asking it to grant what's called a writ of certiorari, which is the mechanism by which the Supreme Court can decide in its discretion to review the proceedings below.
Did a very good job of answering that question. Mrs. Travis, anything else you want to add to that, or no?
Your Honor, I believe Ms. Diaz actually is interested in fielding this question.
Okay.
She knows that we're last because we're right.
I was actually going to just comment, because Attorney Eggleston has done a pretty good job, I think, of articulating kind of the layout for what would be potential next steps. But I did want to say something just relative to the uniqueness of this particular court, the Supreme Court, to the students. And it's sort of, I think, appropriate generally, given the nature of the questions that were presented here. But if any of the students at any point have an opportunity to go back and read the Organic Act, I think it's particularly interesting to look at the historical constitution of the Supreme Court of Guam and the way the Supreme Court was ultimately established for us and became our senior-most level of appellate review locally. And so I guess I don't have anything particular to that question, but I would comment that, to the extent any students are interested in sort of the historical perspective of the Organic Act, I do think that especially the provisions with regard to the courts are an interesting read.
All right, Chief Justice, I think we've pretty much run out of time. It's 12:15. There are a few more questions left, but we weren't able to get to all of them, but we appreciate all the questions submitted by the students from George Washington and the University of Guam in this virtual oral argument outreach.
Thank you, Justice Torres, and I'll just close on behalf of my colleagues. Your performance today, counsels, all of you, is a testament to the caliber of lawyers that we have in our Guam Bar community. Thank you for the excellent arguments, and that you have shown that the caliber of the profession in our community is excellent. And we thank you for your contributions in helping us decide this difficult case. And with that, the court is adjourned. Have a good weekend. You've all earned it. And we'll see you again sometime shortly in our court. Goodbye.
And happy Mother's Day to everyone out there, all the mothers. Goodbye.
Thank you, Your Honors.
Thank you, Your Honor.
Thank you, Your Honor.